Welcome back to the JD Orientation podcast series. In this podcast, I discuss the concept of private law with Professor and former Dean Bruce Feldhusen. We focus on the concept of private law as distinguished from public law, and then hone in on specific topics in private law, including specifically torts, and then a conversation about contracts and property law. I began by asking Professor Feldhusen about his professional background.
Hi, I'm Bruce Feldhusen. I graduated from Western Law School in 1976 and did my master's and eventually my doctorate at the University of Michigan in Ann Arbor. So I began as a full-time law professor at Western in 1977. My dean at the time was David Johnston, who's now the Governor General of Canada, and I guess he was responsible for starting my career, although he might wish to deny that. And I taught at Western until 2000. In January 2000, I began at the University of Ottawa as the dean, and that curtailed a lot of my teaching and writing, of course, being dean, but I have always maintained some writing in the torts field, which we're going to talk about a little today, and I've also taught a large class in torts almost every year I've been here.
Great. And so one of the things we want to talk about today is this concept of private law, of which torts is a subspecies. What really is the distinction between private law and public law?
Well, for me, it's really just a categorization scheme, and arguably it's a bit suspect. But roughly speaking, I would say that the law that regulates interactions between private citizens is typically what is private law, and the law that regulates the government, whether with public or private parties, is public law. Examples might be helpful. So the classic example of public law, of course, is constitutional law, whether you're talking about the Canadian Charter of Rights and Freedom or more traditional Canadian law of division of power between the federal government and the provinces. Both of those are, of course, mandatory teaching subjects here. And then there's administrative law, which deals with the judicial control of regulatory agencies of all sorts, with boards, tribunals, municipal governments. Actually, that's probably the single biggest field of law, period, these days. It encompasses so much, and you'll have some exposure to that in your legislation course, I would think, in first year. And criminal law, which maybe is not so evident, although we'll discuss that a bit more in a minute, is a classic form of public law and also mandatory in first year. In contrast, the classic examples of private law would be property, tort, and contract, all of which are mandatory first-year courses, all of which have been mandatory courses in North American law schools for 150 years. You might find it interesting to know that corporate law is also a classic form of private law, and that's because corporations are, in law, persons, just the same as you and me.
It's often said that private law is heavily dominated by the common law. Is that still true?
Yes, I think it is, certainly relative to most of the examples I gave you about public law. It is. Most of private law developed from English common law, and then, roughly speaking, developed from decisions by individual judges across England that came to be grouped in a hierarchy and eventually were known as precedents. But the term common referring to the fact that eventually across England the judges tried to have the same law of tort, of contract, and of property across there. It's possibly more important that private law be common than public law, because private law is what makes capitalism work, for better or worse. And if you have differences in private law, it's very difficult to trade with other areas and so on. So it would have been of critical importance after the Industrial Revolution that England and its colonies develop law that was the same across the country, and they didn't do it by enacting legislation. They did it by just more or less agreeing amongst the courts that they would respect each other's decisions.
Now, you suggested that the distinction between public and private law is somewhat suspect. What did you mean by that?
Well, so we say public law is about the government, but of course governments own more property than anybody else. Governments contract all the time, and when they contract, they typically contract as private parties and are governed by the same law of contract as anyone else. And governments commit torts, so sometimes the line just isn't as clear as it might be. Or in my own teaching history, the two subjects I've taught the most are tort and administrative law, which are arguably on different sides of that line, and yet what attracts me to that combination are the similarities. I don't mean to disparage the categorization. I think it's useful for a basic understanding of law, and I think that's why we're talking about it today.
You mentioned torts, and of course this is an area where you've spent a good proportion of your career. It's also an area that might seem the most obscure for many students. Most students have some experience with property and they have some experience with contracts, but they may not have encountered a tort. What is a tort?
Well, it's rather than define it, if you'll bear with me, I'll give you an example. And I think what you'll find out is that probably the students know more about tort than either property or contract, although they may not know it by the name tort. So when I begin my torts class, I think on the very first day, I begin with this little example of a fella named Angus, who's an invited expert speaker at a public auditorium on the subject of free trade. And the local labor union happens to be picketing its talk because they don't care for free trade. And out of the blue, one of the picketers, we'll call him Victor, jumps up on the stage and administers a physical beating to Angus. And I asked the class, what's the likely first step of the law in this scenario? And we play around for 15 and 20 minutes. Some of them jump right away into the courts, but I bring them back to the fact that somebody's actually going to have to call the police before anything happens, and the police are going to have to investigate, and maybe they'll arrest Victor, and after interviewing visitors and so on, just to illustrate a bit about the procedure that precedes the court drama with which everyone is in North America is familiar with because of TV. So eventually we get to a criminal trial. And I asked the students what the qualities are of this criminal trial because they are familiar with it. So one of the things I say is, what's the case going to be called? And we arrive at the answer that it's going to be called R against Victor. And who is R but Regina? And who is Regina but the Queen? And we then get into the question about why is the Queen meddling in this at all? And I run through the public aspects of criminal law, which may not have occurred to everyone in the class beforehand. And so what's revealed in this discussion is that Angus really has little or nothing to do with this process. Although Angus may have been the person who was beaten, it's the government that controls the trial, and the government that decides who the witnesses are going to be and not be, and what the questions are going to be. And it's the government really who pays for the trial, all the trappings, including the Crown attorney who prosecutes it and so on. And we then get to the question, when this is all over, what did Angus get out of it? And often the answer is Angus not only didn't get anything out of it, but actually may feel wounded by it, by having been excluded. And at this point, I bring it to their attention that Angus is quite likely to bring a tort case based on exactly the same facts. And this will be a case, and here you see the private-public distinction, where the case will be called Angus against Victor. Angus will have a lawyer who's running that case. Angus's lawyer will decide what witnesses will and won't be called, and so on. And at the end of the day, if Angus succeeds, the remedy in tort is going to be an award of damages, a sum of money, the purpose of which is to put Angus in the position he was in before the accident. It will compensate him for medical expenses, for lost work, for pain and suffering, and so on. And so we juxtapose the two systems that way. So they're precisely the same facts, leading to two very different proceedings. And the private law tort system being far more geared to the control and benefit of the victim. At this point, I actually tell them about some research I've done about tort suits that come out of sexual assaults. So we typically think of a sexual assault as a crime, which of course it is. It's a hideous crime and prosecuted vigorously. But many survivors bring tort suits afterward, and many of them bring tort suits even though the perpetrator has been convicted in criminal law. And often when the perpetrator isn't going to have any money. And all of this suggests to me that the public system does things for the public, presumably, but leaves a lot of gaps to be filled, financial and otherwise, for the private law of tort.
And so tort is about compensation?
I wouldn't say it's about compensation, because it's a terrible compensation scheme. It's slow and expensive and so on, but the remedy is compensatory. I think a purist would say that the remedy is as much an inducement for the private enforcement of law as it is a compensation scheme. If we just wanted efficient social compensation, everybody would be insured, and that would be the end of it. So there's more to it than that. Some people speak about the purpose of tort as corrective justice, righting wrongs between two private parties.
You've used the example of a person being beaten as an example of a tort. That would be the tort of battery, presumably.
That's right.
What other torts are there?
Well, so you have a slew of torts that are based on intentional wrongdoing, and they're the hitting and beating torts, if you like. So you have battery, which is striking a person without her consent. You have assault, which is making someone fear they are going to be struck without their consent. You can see the common history between crime and tort from the somewhat common terminology. And you have torts of various names which deal with people taking your property, damaging your property, these kinds of things. So these are the intentional wrongdoings. But the most common form of tort action would be an action in negligence, which is basically seeking a remedy for people who have injured someone carelessly. And this would take into account products liability cases people will know, medical malpractice cases would be another classic example. Interestingly, certainly at one time it would have included automobile accidents, but most automobile accidents are now removed from tort law by legislation and dealt with by insurance and workplace legislation, and that takes workplace injuries out of the system. So we're left with sports injuries is another category. The very important are lawsuits against the government, and also lawsuits against people who sell and otherwise provide liquor, things like that.
And so these kind of lawsuits, this is what we would mean by a civil action?
That would be called a civil action for damages, that's right.
And what about the term cause of action? What does that mean?
Cause of action is a famous name for a tort. If you want to sue someone in tort, there has to exist something which is called a cause of action, which is an existing tort, if you like. Courts can make new torts, but usually there has to be a pre-existing cause of action. So battery is a cause of action, negligence is a cause of action, nuisance is another cause of action, defamation, where one damages another person's reputation by publication, is another cause of action in tort. And also some of the students may be familiar with the term class action, which is a very important vehicle for social change right now. And class actions are when you have a group of people who suffer substantially the same wrong from substantially the same defendant. And if a judge agrees that there's a common issue there, it's tried all at once, and it dramatically reduces the costs of each individual doing it. A few years ago, an American news magazine had a cover of a famous trial lawyer on the United States, and in it, it put the hypothesis forward that no form of law had created more social change in the United States than tort law. And they looked at the toxic tort suits against the makers of Agent Orange. They looked at the tobacco litigation. They looked at the products liability legislation. All these kinds of behavioral changes that have been affected by tort law. And that's why I said I think the students probably know a lot more about tort law than they think.
One of the classic images one has of law school is of the so-called Socratic method, which is most commonplace in the private law subjects like tort and contracts. Could you describe a bit, because you use Socratic in your teaching, what is the Socratic method of teaching?
Actually, I don't use a pure Socratic method. I'm not sure anyone does anymore, but in the pure form, the instructor asks a question, the student answers, and the instructor asks another question, and another question, and another question, either of that same student or of other students, but there are no answers given by the instructor. That's, and it's based, of course, on the manner in which Socrates was purported to have taught. But so in the best example I've ever seen of it in law school can be found in a movie called The Paper Chase, which is still shown at many law schools in orientation week.
And in fact, is on Netflix.
Is it? Well, I recommend everybody get it and watch that. And I certainly had a lot of Socratic professors. I liked it. My feeling is some students love it and some students hate it, but very few have no opinion about it. And the advantages of it, I think, and I don't do it purely, I certainly give some guidance, is I'm a pluralist about teaching. There's no one way I think that's better than another, and students should be exposed to a range of them. But my way is not to come in and think good teaching is point 1, point 1A, point 1B, and the student transcribing and fooling herself into thinking she learned something or I taught something. And I think that's what books are for. So I like to play around with the material. What if, and so on. And what it means is everybody in class, they don't know if they're going to be called upon or not, so they're listening and they're thinking through that time. It's exhausting for me, exhausting for them, and I wouldn't wish it on everybody for every class, but I hope everybody gets some.
Anything else that you'd like to discuss about private law in the University of Ottawa program?
Well, first of all, I didn't say anything about the other two ones, and I should just say briefly that if I go back to my Angus example, what I say to the class, suppose Angus had been threatened, and so he hired a bodyguard who sat on stage and watched him while he were beaten. His lawsuit there would presumably be a suit for breach of contract against the bodyguard, and the difference between a contract and a tort, if you like, is the tort of battery. Courts have defined. They've told you it is the touching of another person without consent, and that's a social definition of the wrong. A breach of contract means the parties decide what obligations they owe one another. The law enforces them, and the reason the law enforces contract is that's how we have trade and exchange, and without that we don't have capitalism. But the content of the bargain, subject to some limitations, is set by the parties, and that's the law of contract, I think. And property law, I don't know about you, I've never been able to understand property law, but the most interesting thing about property law is property is not a thing. Property is a bundle of legal rights and obligations that are associated with a thing. And so, or not even always with a thing. So you have what's called real property, and that's land. And that has a very distinct set of laws. So if you're the owner, you have certain rights, but you might be a mortgage lender, or you might be a secured creditor, or a tenant, and all of you have different rights and obligations in that property. And there's a similar regime for personal property. And now the most interesting kind of property is a complete abstraction. It's intellectual property. And intellectual property, there is no thing. It's a total creation creation of the law. And that is the thing that protects ideas and expressions of ideas, and again allows them to be marketed in a capitalistic society. So the irony is that China, for example, doesn't have much intellectual property or much respect for Western intellectual property, and it's only because it's trying to enter into a capitalist phase of its economy that it has to develop an intellectual property regime. So all of those are taught here. I mean, one of the things we have at Ottawa is one of the leading intellectual property programs in the world, for example. I think we have a good balance here between public and private, myself, in part because we have so much choice, but even in our mandatory courses, I think we're split pretty equally between public and private.
Perhaps as a final question, and in your capacity as the outgoing dean, what recommendations would you make to students in the way they approach their legal education and what they should hope to get out of it generally while students here at the University of Ottawa?
Well, first of all, I mean, it's a means to an end for sure, or a means to various ends, but no one should spend 3 years of their life in a means to anything. It should also be an end in itself. So they shouldn't be wasting time here. They shouldn't be hating it, and they shouldn't be goofing off and so on. They should really embrace it. There's so many different ways to embrace it here. They can be volunteers, they can be public lawyers, private lawyers, whatever, but they really should engage. They're reaching an age and a stage where 3 years is too long to write off. They are to just get over with or whatever. They should engage. And I think I would always look for stars, even if they're teaching in areas in which you think you have no interest. You really will never know. Go to the people that have fabulous reputations at least once. You never know what you're going to find, and along with that, I would have an open mind. It's the world is changing fast, and the nimble will survive the best.
Thank you very much.
My pleasure.